says, which is different from what my friend...
I'm just curious why.
So if I could give you a little background, it'll make more sense.
The underlying rationale is for that.
Yes, I think the history is very helpful here. So before 2002, the BIA was reviewing everything de novo, including facts.
I got the history. I'm just like, what is the reason
that
makes sense?
So
why, like Judge Collins said, why something that's treated as a question of law transforms into a question.
So here's where I was going. It's not that it's a question of law. What the regulation says is we're going to stop the de novo thing. We're going to do clear error for facts, but we don't want that to mean that judgments and questions of discretion are not subject to de novo review. And it said judgments include decisions about whether the applicant has shown past persecution.
That's telling me what the regulation is. I'm still trying to get at
yeah, well, my answer is because it's a question of judgment, and both the BIA and the IJ share the responsibility to exercise.
What's the difference between a question of judgment and a question of law?
Because judgment is the question about weighing...
In this context.
So the question about weighing facts and determining whether it's persecution is going to involve judgment, and both the BIA and the IJ have expertise in looking at recurring fact patterns and seeing all kinds of different versions of these cases, far more cases than any court of appeals is ever going to see. And as this court recognized in Ming Dai and Orlando Ventura in many cases, the agency has expertise here to apply to deciding those questions. So the AG decided, we'll do clear error, but I'm going to reserve more review for these judgment questions. That doesn't mean that Congress wanted courts of appeals engaging in that kind of judgment in the first instance. And as was already said and admitted, the way that the BIA engages in review, the way that the AG designs internal review has no bearing on that. For example, the BIA reviews questions of discretion de novo. No one thinks the Court of Appeals should do that. It reviewed facts de novo before 2002. No one thinks the Court of Appeals should be doing that either.
If we repeat what you write in your brief on page 40, you think the lower courts are already doing that? Namely,
yes, I do. I think they were doing that before IRIRA. I think they're doing that now. I think it's standard practice where if a petitioner says, look, regardless of the way my facts cash out, the BIA stated the wrong standard and used a standard that's incorrect, that is a question that courts review de novo.
And to show that the standard is incorrect, again, on extreme suffering, what would you have to say? We think extreme suffering is too high a bar.
So there have been questions that have come up. So like one that happened earlier was, is evidence that there's lots of crime in my country and I'm very likely to be a victim of crime, is that relevant to persecution? And the court said, no, that's not relevant to persecution.
That's legal?
So like, is it ever relevant, right? Is it ever going to be relevant to persecution? Legal question, it's not like, look at the facts in my case, it's like, this is the standard. And there are other questions like that where questions about whether the standard should be lower in certain circumstances and so on. So the other thing I just want to emphasize is that this court in Wilkinson really already talked about this some and cited the US Bank sort of formulation and said, and applied it there and said, application of the term extreme hardship, which is kind of very analogous to the question of extreme suffering, that is going to be something that is primarily factual and reviewed deferentially. I think the petitioner's contrary arguments are really saying the thing that this court was resisting in both Guerrero-Lasprilla and in Wilkinson, which is that every mixed question, no matter how factual it is in the INA, is going to be subject to de novo review. I mean, that really would be a sea change, and it's really irreconcilable with IRIRA. The other thing that I'll note, as Justice Jackson, you pointed out, I mean, the thrust of IRIRA was Congress was coming in and then overturning things that courts of appeals were doing. I don't think there's any realistic chance that you could look at IRIRA and think that Congress was silently departing from the substantial evidence review consensus for persecution questions and asylum eligibility generally in adopting IRIRA. Unless there are any further questions.
Mrs. Thomas?